Okay, Rule 111, Prosecution of Civil Actions, Section 1, Institution of Criminal and Civil Actions. So when a criminal action is instituted, the civil action for the recovery of the civil liability arising from the offense charge shall be deemed instituted with the criminal action unless the offended party waives the civil action, reserves the right to institute it separately, or institutes the civil action prior to the civil action. So what is deemed instituted in the criminal action is the civil action ex delicto. So remember, in civil law, we have 5 sources of an obligation. First, law, no? Second, contracts. Third, quasi-contracts or parang kontrata. Fourth, delicts. And fifth is quasi-delicts. Ayan. So, ano yung sinasabing deemed instituted in the criminal action? Ito yon, yung delicts. Ayan. So, sabi rin dyan, while the civil action ex delicto is deemed instituted, there are also exceptions. So, ano yung exceptions? One, when the offended party waives the civil action. Second, if he reserves the right to institute it separately, or the civil action is instituted prior to the criminal action. So, sabi dito sa section 1, second paragraph, the reservation of the right to institute separately the civil action shall be made before the prosecution starts presenting its evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. So, yung reservation ay pwedeng gawin ng offended party, no? Ayun, except in BP 22 cases and those offenses committed by public government officials in the RPC. So, kapag itong dalawa, hindi nyo pwedeng i-reserve ang institution of civil action. Yan. So, ang reservation of civil action should be done before the prosecution starts presenting its case. Yun. Pero, ang titingnan kasi natin dito is itong under circumstances affording the offended party a reasonable opportunity to make such reservation. So, kailan ba yan nangyayari? Kasi, when the crime charge, o kunyari example, when the crime charge is homicide, so ang homicide is a non-capital offense. And then, the accused pleads guilty during his arraignment. So, pag nag-plead guilty kasi siya sa non-capital offense, the judgment will also be promulgated on the same day. So, there will be no more presentation of evidence by the prosecution. So, may the offended party still reserve the filing of a separate civil action? Yes, pwede. Because the court will give him a reasonable opportunity to make such reservation. Yun. We have to take note also that independent civil action can be filed without the need of reservation and proceed separately from the criminal action. So, mamaya sa sa mga next na sections, itong Rule 111, ilalagay doon kung ano yung mga independent civil action sa Rule Section 32, 33, yun, ng Civil Code. Yan, so, third paragraph, when the offended party seeks to enforce civil liability against the accused by way of moral, nominal, temperate, or exemplary damages, without specifying the amount thereof in the complaint or information, the filing fees thereof shall constitute a first lien on the judgment awarding such damages. Where the amount of damages other than actual is specified in the complaint or information, the corresponding filing fee shall be paid by the offended party upon the filing thereof in court. Except as otherwise provided in these rules, no filing fee shall be required for actual damages. No counterclaim, cross-claim, third-party claim may be filed by the accused in the criminal case, but any cause of action which could have been the subject thereof may be litigated in a separate civil action. Okay, the criminal action for violation, ayun na pala yung sinasabi ko kanina, exception. Criminal action for violation of BP 22 shall be deemed to include the corresponding civil action, and no reservation to file such civil action separately shall be allowed. Upon filing of the aforesaid joint criminal and civil action, the offended party shall pay in full the filing fees based on the amount of the check involved, which shall be considered as actual damages claim, where the complaint or information also seeks to recover liquidated, moral, nominal, demerit, or exemplary damages. The offended party shall pay additional filing fees based on the amounts alleged therein. If the amounts are not so alleged but any of these damages are subsequently awarded by court, the filing fees based on the amount awarded shall constitute the first lien on the judgment. And last paragraph, where the civil action has been filed separately and trial thereof has not yet been commenced, it may be consolidated with the criminal action upon application with the court trying the latter case. If the application is granted, the trial of both actions shall proceed in accordance with Section 2 of this rule governing the consolidation of the civil and criminal action. So, Section 2, when a separate civil action is suspended. So, after the criminal action has been commenced, the separate civil action arising therefrom cannot be instituted until final judgment has been entered in the criminal action. If the criminal action is filed after the said civil action has already been instituted, the latter shall be suspended in whatever stage it may be found before judgment on the merits. The suspension shall last until final judgment is rendered in the criminal action. Nevertheless, before judgment on the merits is rendered in the civil action, the same may, upon motion of the offended party, be consolidated with the criminal action in the court trying the criminal action. In case of consolidation, the evidence already adduced in the civil action shall be deemed automatically reproduced in the criminal action without prejudice to the rights of the prosecution to cross-examine the witness presented by the offended party in the criminal case and of the parties to present additional evidence. The consolidated criminal and civil action shall be tried and decided jointly. During the pendency of the criminal action, the running of the period of prescription of the civil action, which cannot be instituted separately or whose proceeding has been suspended, shall be tolled. The extinction of the penal action does not carry with it the extinction of the civil action. However, the civil action based on delict shall be deemed extinguished if there is a finding in a final judgment in the criminal action that the act or omission from which the civil liability may arise did not exist. Okay, so Section 2 kasi talks about um, a case where the civil action is instituted prior to the criminal action, but this does not include the independent civil action, but only the civil action arising from the offense charged or the civil action ex delicto. So, if the civil action is filed first, and while pending, the criminal action is instituted, what will happen to the civil action? Well, it shall be suspended in whatever stage before judgment on the merit. Paano kung meron ng judgment yung civil action and then nag-institute ng criminal action? When there is already a judgment in the civil action, it will no longer be suspended. That is the meaning of before the judgment on the merit. So, kung ganun ang nangyari, ang pwede namang remedy ay i-consolidate, no? Yung civil action with the criminal action. So, kaso hindi nga lang ito automatic, it must be upon the motion of the offended party. So, where will you file the consolidations? In the court trying the criminal action. And what is to be consolidated is the civil action with the criminal action. So, paano kung kunwari, you will be consolidating the cases, no, the civil action with the criminal action. Pero the court trying the criminal case has no jurisdiction over the civil action. Pwede pa rin bang ma-consolidate? Yes, of course, even if it is beyond the jurisdiction of the court or its rank. So, we have to note then, sinasabi din dyan sa Section 2 that when there is a consolidation, the two cases will be tried jointly and a joint decision is rendered. Those evidence already taken in the civil case will be deemed reproduced in the criminal case, subject to the right of the party to present additional evidence. But there is also one instance, no, na hindi yung civil action ang nasususpend but it is the criminal action, and that is this one prejudicial question, no? So Ang prejudicial question ay nangyayari when there is a previously instituted civil action in which is similar or intimately connected with the issues raised in the subsequent criminal action. And 2, the resolution of the issue will determine whether the criminal action will proceed or it will determine the guilt or innocence of the accused in the criminal case. So yan, ang masususpend kapag may prejudicial question is the criminal action. Yan. Section 3, when civil action may proceed independently. So, in cases provided in mga Articles 32, 33, 34, and 2176 of the Civil Code of the Philippines, the independent civil action may be brought by the offended party. It shall proceed independently of the criminal action and shall require only preponderance of evidence. In no case, however, may the offended party recover damages twice for the same act or omission charged in the criminal action. Section 4 is the effect of death in civil action. So, the death of the accused after arraignment and during pendency of the criminal action shall extinguish the civil liability arising from the delict. However, the independent civil action instituted under Section 3 of this rule or which thereafter is instituted to enforce liability arising from other sources of obligation may be continued against the estate or legal representative of the accused after proper substitution or against the estate, as the case may be. The heirs of the accused may be substituted for the deceased without requiring the appointment of an executor or administrator, and the court may appoint a guardian ad litem for the minor heirs. The court shall forthwith order the said legal representative to appear to be substituted within a period of 30 days from notice. A final judgment entered in favor of the offended party shall be enforced in a manner specially provided in these rules for prosecuting claims against the estate of the deceased. If the accused dies before arraignment, the case shall be dismissed without prejudice to any civil action the offended party may file against the estate of the deceased. So, penal extinction. Okay, sa Section 4, sinasabi lang dyan, the extinguishment of the criminal action does not follow the extinguishment of the civil action. However, the civil action based on delict or the offense charge may be deemed extinguished if there is a pronouncement in the final judgment in the criminal action that the act or omission from which the civil liability may arise did not exist, or if the accused because if the accused is not the one who committed the crime, then it is just illogical to hold him civilly liable. So we have to remember, we have two kinds of acquittal. Ang pangit ng sulat. So two kinds of acquittal. One based on reasonable doubt. If the accused is acquitted based on reasonable doubt, the accused may still be held civilly liable because of reasonable doubt. If the accused is acquitted based on a finding that the accused did not commit the crime, then this kind of acquittal will also foreclose the civil liability. Okay, so Section 5, the judgment in civil action not a bar. A final judgment rendered in civil action absolving the defendant from civil liability is not a bar to a criminal action against the defendant for the same act or omission subject in the civil action. Bakit? Kasi magkaiba sila ng quantum of evidence. So, Section 6, suspension by reason of prejudicial question. A petition for suspension of the criminal action based upon the pendency of prejudicial question in civil action may be filed in the office of the prosecutor or in the court conducting the preliminary investigation. When the criminal action has been filed in court for trial, the petition to suspend shall be filed in the same criminal action at any time before the prosecution rests. And last section, elements of prejudicial question. That the previously instituted civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action, and that the resolution of such issue determines whether the criminal action may proceed or it determines with the innocence or guilt of the accused. And that ends Rule 111.